Hi, my name is Jacqueline Laman. What I'm going to tackle to you today is from Module 11, which is Intellectual Property Rights. Intellectual property. It is a property that arises from the human intellect. It is also refers to inventions, literary and artistic works, symbols, images, names, and designs used in commerce. There is an organization called World Intellectual Property, which is established in 1970. It is an international organization dedicated to ensuring that the rights of creators and owners of intellectual property are protected worldwide and that inventors and authors are thus recognized and rewarded for their ingenuity. However, exclusive rights of the scientists, researchers, inventors, artists, and other gifted citizens in our country are not suitably protected as they should be. Most of them have apprehensions in applying for intellectual property. There are three branches of intellectual property rights. Number one is patent, next is trademark, and last is copyright. Patent is a right granted by the government to prevent others from selling, making, or using your invention. A patent has a term of 20 years, providing an inventor significant commercial gain in return. The patent owner must share the full description of the invention. The patentable invention is any technical solution of a problem in any field of human activity which is new, involves an inventive step, and industrially applicable shall be patentable. The non-patentable inventions are discovery, scientific theory, mathematical methods, performing mental act, playing games, doing business, program for computer, method for treatment. A method for treatment is it can be human or animal body by surgery or therapy and diagnostic method. Plant variety or animal breeds or essentially biological processes for the production of plants and animals. Aesthetic creation, and the last is contrary to public order or morality. There are some requirements for patentability. Number one is novelty. A novelty is the quality of being unique, new, original, or unusual. Number two is inventive steps. It is this it distinguishes if an invention is new or just obvious improvement. And last is industrial applicability. It is also known as the industrial application, which means it is patentability requirements and generally patents are granted for inventions that can be used in some kinds of industries. The requirements for filing a patent are request for the grant patent, description of the invention, drawings necessary for the invention if any, and last is filing fee. Next is trademark. Trademark is a tool used that differentiates goods and services from each other. It is very important marketing tool that makes public identity goods and services. Mark means any visible sign capable of distinguishing the goods or the trademark or services or what we call service mark of an enterprise. It can be names of products or services, logos, slogans, packaging, and even sounds and smells. In essence, a trademark can be almost anything that is used to identify a particular product or services. There is what we call the trademark protection. A trademark can be protected through registration. Registration gives the trademark owner the exclusive right to seal the mark and to prevent others from using the same or similar marks on identical or related goods and services. Here is a tip for trademark registration. It would help if you conduct a research in the trademarks database to determine if there are identical or similar marks that would prevent the registration of your mark. This is to prevent future conflicts with marks that are already registered or with earlier filing dates. The last branches of intellectual property rights is copyright. It is the legal protection extended to the owner of the rights in an original work, literary and artistic works, novels, poems, plays, films, musical works, drawings, paintings, photographs, sculptures, and architectural designs. Works are protected by the sole fact of their creation, respective of their mode of or form of expression, as well as their content, quality, and purpose. These are the works covered by copyright protection: books, pamphlets, articles and other writings, periodicals and newspapers, lectures, sermons and addresses, letters, dramatic or dramatical musical compositions, choreographic works or entertainment in dumb shows, musical composition with or without words, works, original ornamental designs, illustrations, maps, plans, sketches, charts, drawings or plastic works of a scientific or technical character, computer programs, pictorial illustrations and advertisements, and other literary, scholarly, scientific, and artistic works. The term of protection of copyright. In general, the term of protection of copyright originally and derivative works is the life of the author plus 50 years after his death. The code specifies the term of protection for the different types of works. In calculating the term of protection subsequent to the death of the author shall run from the date of his death or of publication, but such term shall always be deemed to begin on the first day of January of the year following the event which gave rise to them. For example, death, publication, making. Copyright consists in infringing any right secured or protected under the code. It may also consist in adding or abetting such infringement. The law also provides for the liability of a person who at the time when copyright subsists in a work has in his possession an article which he knows or ought to know to be infringing copy of the work for the purpose of selling or letting for hire, distributing the article for the purpose of trade exhibit of the article in public. This Republic Act number 8293 is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for the other purposes. Republic Act number 8293, it shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people, for such period as provided in this Act. The use of intellectual property bears a social function. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national deployment and progress and the common good. It is also the policy of the state to streamline administrative procedure of registering patents, trademarks, and copyright, to liberalize the registration and transfer of the technology, and to enhance the enforcement of intellectual property rights in the Philippines. Software piracy, in simple term, is stealing copyright software. This software could be a game, an application, a music CD, or an entire operating system. In comparison to literature, music, and movies, computer software is a new form of intellectual property. However, the same laws govern computer software, and stealing this property is no different from stealing any other form of copyright content, and the punishment for doing so is the same. How does software piracy affect you? The most obvious and direct impact would be if you partake in software piracy. You put yourself at risk to corrupt files intended to steal personal information or damage your computer. Even if you do not partake in software piracy, it has a direct impact on you because of the strain it puts on society. The global economy alone loses approximately $12 billion a year on software piracy, which doesn't include other forms of stolen media such as movies and music. The types of software piracy are soft-lifting, hard disk loading, client-server overuse, counterfeiting, and online piracy. Soft-lifting is the most common type of software piracy. This often occurs in business or school environments and is usually done to save money. Hard disk loading often happens at PC resale shops and buyers are not always aware that the additional software they are buying is illegal. Client server overuse often happens businesses are on local area network and download the software for all employees to use. Counterfeit usually sold at a discounted price in comparison to the legitimate software. And online piracy, this is usually done through a peer-to-peer file sharing system, which is usually found in the form of online auction sites and blogs. The three main types of piracy are end-user piracy, reseller piracy, and BBS or internet piracy. End-user piracy is using multiple copies of a single software package on several different systems or distributing registered or licensed copies of software to others. Another common form of end-user piracy is when a cracked version of the software is used. Hacking into the software and disabling the copy protection or illegally generating key codes that unlocks the trial version, making the software a registered version creates a cracked version. Next is reseller piracy. Reseller piracy occurs when unscrupulous reseller distributes multiple copies of a single software package to different customers. This includes preloading systems with software without providing original manuals and diskettes. Reseller piracy also occurs when resellers knowingly sell counterfeit versions of software to unsuspecting customers. The last type of software piracy is internet piracy. It occurs when there is an electronic transfer of copyright software. If system operators and or users upload or download copyright software and materials onto or from bulletin boards or internet for others to copy and use without proper license. Often hackers will distribute or sell the hacked software or cracked keys. The developer does not receive any money for the software the hacker distributed. This is an infringement on the developer's copyright. Another technique used by software pirates is to illegally obtain a registered copy of software. Pirates purchase the software once and use it on multiple computers. Purchasing software with a stolen credit card is another form of software piracy. Unfortunately, there are many kinds of software piracy that has hampered the software industry. These are the legal penalties for software piracy: copyright infringement, civil penalty, and criminal charges. Software piracy is unauthorized use and or distribution of software. This includes anything from music, movies, and video games to document software such as Microsoft Office, Adobe, and imaging programs. Something as innocent as installing a program on more than one computer if the copy was intended for only one computer can constitute piracy. Copyright infringement. Since the piracy of copyright software leads to huge monetary losses, a civil lawsuit usually requires that the infringer pay for all losses resulting from the distribution and/or illegal copying of the software and any profits the violator made from it. Civil penalty. This means that for every single program or work that was illegally copied and or distributed, the infringer could have to pay $150,000. As you can imagine, a civil suit may cost a violator millions of dollars. And last is criminal charges. This involves damages that are both monetary and psychological. A prison record can seriously harm the life of any individual. This is all for now. Thank you for watching and, of course, listening.